So now we'll move to the Euthanasia Prevention Coalition. Not sure who's speaking first. Mr. Scher?
Thank you, Mr. Chairman, members of the committee. My name is Hugh Scher, and I'm the lawyer for the EPC. I'm a constitutional lawyer with over 20 years' experience, and I was counsel before the Supreme Court of Canada in the Carter decision, and have been engaged in almost all end-of-life cases, including Rodriguez, through Latimer, through Razulli, through Carter, at the Supreme Court and other levels of court. EPC seeks to raise 4 fundamental points to the attention of the committee. First, we seek to address the concern about blanket immunity relative to any members that participate in acts of assisted suicide or euthanasia under the bill. Such examples would include in Section 241 sub 3 and 241 sub 5, which states that no person is subject to an offense if they assist with or otherwise engage in such actions pursuant to the things, provided they're doing so in a manner that does not expressly violate. But again, the language is not clear. There's no such meaningful blanket immunity in any jurisdiction in the world where euthanasia or assisted suicide are legalized. So I would just simply put it out there that the blanket immunity that's applied for those who assist or otherwise engage in this conduct is not something that's found around the world in those jurisdictions where it is in place. And Ms. Hasbrook has other suggestions in that regard. The second point I would address is the concern related to the limited safeguards that are contained in the bill and the fact that they are in many respects woefully inadequate in terms of addressing the kinds of concerns as other witnesses have here testified to here today. The limitations are extremely narrow in scope, and they basically seek to look at the same kinds of limitations that would apply in the context of a healthcare decision-making process: voluntariness, consent, capacity, and then the need for a doctor or 2 doctors to sign off. These are not adequate safeguards, and they will become and have become illusory in those jurisdictions where other jurisdictions have them in place. In Belgium, for example, in the Flanders region of Belgium, based on the death certificate studies that were conducted, we know that in 32% of cases of euthanasia, people were killed without request. They were killed without consent, despite a legal requirement for those things to occur. And in 47.1 of those cases, not one of the doctors that engaged in these actions contrary to the law was prosecuted. These statistics are found in the documentation that was before the Supreme Court of Canada and indeed in the Supreme Court's reasons themselves. Third point I would address is the question of oversight. And I would submit to you that, contrary to what you've heard earlier about the concerns around legal oversight and adjudicative oversight, the reality is that what the Supreme Court of Canada has now put in place in terms of judicial oversight is what is required in order to ensure a level of independent assessment and adjudication by a third-party neutral to determine that the criteria, whatever they may be, that are established by the Parliament of Canada are in fact addressed and adhered to. We have serious concern about the notion of leaving these oversight measures in the hands of simply doctors and nurses themselves, who are themselves engaging in and carrying out the acts that are the subject of the legislation. And what the Supreme Court of Canada has put in place by way of an interim measure is to provide for a level of judicial oversight, and that seems to have been working fairly well and relatively unobtrusively. And I would urge this tribunal, this committee, to seriously consider implementation and continuation of the measure that the Supreme Court of Canada has itself put in place in order to ensure a level of independent oversight that the Supreme Court itself felt was appropriate to the circumstances. The third point I would address is a question around fraud and transparency. The bill, to some extent, goes to address this, but we know in other jurisdictions, and in the province of Quebec, for example, that death certificates are effectively falsified by doctors to reflect not the actual cause of death as being that of euthanasia, but rather relating back to the underlying illness of the person. And it is impossible to have reasonable and meaningful transparency and oversight on a system predicated and based upon a fraud. And I urge this committee to bear that in mind and to implement measures that will ensure that that kind of fraud and transparency are addressed expressly in the context of the legislation itself. The failure to do that makes it almost impossible to monitor and to oversee these practices both on a present level and on a go-forward basis, in which case it becomes impossible to meaningfully assess and to actually, in fact, address the kinds of abuses that may well be a concern and may well actually take place. How can you do so based on a system that doesn't allow for proper, effective, adjudicative oversight? I'm going to turn it over to Ms. Hasbrook to continue and address you further in questions.